सभी स्टूडेंट्स को मेरा नमस्कार। आशा करता हूँ आपको मेरे वीडियोस पसंद आ रहे होंगे। तो प्लीज़ मेरे चैनल को शॉर्ट हैंड लीगल डिक्टेशन को प्लीज़ सब्सक्राइब करें और लाइक करें तथा अपने फ्रेंड्स से भी बोलें कि मेरे चैनल को शेयर, सब्सक्राइब और लाइक करें। सो आज का डिक्टेशन हम 80 से 90 वर्ड पर मिनट की स्पीड के बीच में लेंगे, जो कि लीगल डिक्टेशन होगा। सो बी रेडी। 3, 2, 1, start. Every time when the authorities decided to withdraw the acquisition proceedings, power given under Section 48 of the Act was exercised. In our opinion, after taking possession of the land in question from the landowners, power under Section 48 of the Act could not have been exercised. Para. Though this is the third round of the litigation, it is an admitted fact that an effort to withdraw the land in question from the acquisition proceedings was initiated only after possession of the land in question was taken from the landowners, and Section 48 bracket में 1 bracket close of the Act does not permit withdrawal of acquisition proceedings of any land after possession of the land is taken. Para. Possibly the court was having some sympathy for the landowners, and therefore some recommendations were made by the court with regard to making representation to the government authorities about withdrawal of the acquisition proceedings in respect of the land in question. But every time withdrawal of the land from acquisition proceedings were followed by cancellation of the withdrawal. Para. Be that as it may, the court were quite sympathetic towards the landowners, and therefore every time the landowners were asked to make a representation to the government, and therefore these 3 rounds of litigation have taken place, which in our opinion is not fair or justifiable. In our opinion, it was also not just and proper for the court to show undue sympathy towards the landowners by asking them to make a representation when it was against the legal provisions to withdraw the land from acquisition in view of the provisions of Section 48 of the Act. Such undue sympathy has relegated the landowners to this long drawn litigation, which has not helped them at all. Para. The fact remains that the land in question is required for a public purpose, that is, for widening of a road. There is no need to say that under the Act the state has power to acquire land for public purpose, and widening of a public road is definitely a public purpose for which the land can be acquired. Para. We have considered the submissions made by the learned counsel appearing for both the sides. In view of the aforesaid facts, we are of the view that the acquisition proceedings could not have been quashed by the High Court, especially when the government had not acted in accordance with law while withdrawing the land in question from the acquisition proceedings. Full stop. In view of the fact that civil appeal has been allowed, the contempt proceedings would not survive and are accordingly disposed of. आशा करता हूँ आपको मेरा डिक्टेशन पसंद आ रहा होगा। धीरे धीरे मैं 100 और 120 भी दूंगा, और कुछ चीज़ें मुझे आपको इम्पोर्टेंट इसमें बतानी है कि कैसे कैसे इसमें पंक्चुएशंस, कैसे कैसे इसमें कॉमास यूज़ किए जाते हैं। वो वाले डिक्टेशंस भी मैं आपको दूंगा जिसमें कॉमा, पंक्चुएशन सारी चीज़ें होंगी, जिससे कि आपका हाथ इतना सेट हो जाए कि आपको ये पता हो कि कहाँ कॉमा लगाना है, कहाँ पे फुल स्टॉप लगाना है, कहाँ अपॉस्ट्रोफी लगाना है। प्लीज़ सब्सक्राइब एंड लाइक माई चैनल। थैंक यू।